Welcome to the webinar. My name is Nancy Barnes. I'm a partner in the Cleveland and Chicago offices of Thompson Hine, and I serve as the firm's labor and employment practice group leader. I am delighted to introduce my labor and employment colleague, who's also presenting today, Cleveland associate Brittany Mallow. For the next hour, we will discuss the recent EEOC release of the Pregnancy Workers Fairness Act, PWFA final rule, and how this will impact employers with 15 or more employees. We will provide you with tips for managing accommodations for pregnancy-related conditions and review pending litigation on this topic, as well as offer some practical tips. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees, including the PowerPoint, within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the question box, which is located in the control panel on the upper right side of your screen. We will answer as many of the questions as we can at the end of the webinar. Thank you so much for your interest, and now we will begin. So let's start just with a quick overview of our agenda today. We're going to talk a little bit about the PWFA. This went into effect last year, but just a few basics about the Act itself and its history. We will be covering some distinctions from the Americans with Disabilities Act because both of these laws require an accommodation and interactive process, but there are some distinctions between the two laws. We'll talk about some of the medical conditions that are covered, documentation requirements and no-nos, some accommodations and predictable assessments, which is a new term that's used under the PWFA. We will talk about the concept of undue hardship and when that might apply. We will also advise you regarding prohibited practices under the PWFA, remedies and enforcement. Hopefully you never have to deal with that. And then finally, some practical tips. And if we have time, we will try to address any questions that are put in the chat box for us. So let's talk a little bit, just as a reminder, about what the PWFA is. This is a law that went into effect last June. So a lot of attention has been provided to the rule that came out in April, which will go into effect a little bit later this year. But the law itself is already in place. This is already impacting you if you have more than 15 employees. So again, as a reminder, the PWFA guarantees an affirmative right to receive reasonable accommodations. These are all things that we're going to talk about during the course of this webinar for known limitations that are related to or affected by or arising out of pregnancy, childbirth, or other related medical conditions. We're going to talk about what that includes, unless it would impose an undue hardship on the employer. So also keep in mind that this law does not just impact employees, it's also applicable to applicants for positions with your organization. So just a little bit of a reminder here, the PWFA is building upon some pregnancy discrimination rules and laws and case law that have been in place under Title VII and also the Americans with Disabilities Act, the ADA. So as you may know, Title VII was amended by the Pregnancy Discrimination Act in 1978. So that's been around for quite some time now. The PDA requires that there be no discrimination specifically based on pregnancy and requires employers to treat pregnant workers the same as it would other workers who need similar sorts of limitations or with respect to the terms and conditions of employment. That law was then amended by the PWFA, which went into effect in 2022. So the PWFA is really focused on the issue of accommodations, which is a topic most of us are familiar with because we've been dealing with the ADA for quite some time. Now, as you may recall, the ADA does not include pregnancy as a disability under the ADA. And why is this important? It's important because the PWFA is essentially kind of filling a gap that existed because the ADA didn't apply to pregnancy. But it's also important because this is a fact that sometimes your managers or sometimes HR professionals will kind of latch on to, oh, pregnancy is not a disability under the ADA. So, kind of the accommodation construct doesn't apply to pregnancy. And we need to make sure that people who are sort of your front line on these issues are aware that the PWFA has really changed the landscape here. So prior to the PWFA, there was no individual right to an accommodation under the ADA. And the world has now changed now that the PWFA is in effect. You may also be familiar with the PUMP Act, which deals with providing reasonable break time and space for nursing mothers to be able to pump at work or during working hours. The PWFA also addresses issues related to lactation. So there's some overlap, and there are some areas where the two acts differ from each other. Another thing to keep in mind, and Brittany's going to be talking a little bit more about the lactation issues, but another thing to keep in mind is that the PWFA also covers actual nursing as opposed to just pumping. So for example, if the workplace provides for on-site childcare and the child is nearby and the working mother would prefer to go down to the childcare facility and nurse the child, that's something that's going to be covered by the PWFA. It's not covered under the PUMP Act. So when Congress passed the PWFA, it did direct the EEOC to issue implementing regulations and to provide examples of what would be a reasonable accommodation. And after a long period of time, on April 15th, the EEOC finally released its 408-page final rule. I highly recommend it if you're suffering from insomnia. Just pull that thing out and you will solve your insomnia issues. But it does include a ton of information about how the EEOC responded to the comments that it received. And it also provides interpretive guidance, which if you haven't looked at this previously, it does provide, in some cases, some very helpful examples to identify, what's an undue hardship, what's a reasonable accommodation, etc. So it can be helpful. And just as a reminder, the final rule will take effect on June 18th, 2024. And again, the law itself is in effect now. The rule, which is what we're going to be focusing on today in our presentation, will take effect in just about a month. So let's talk about a little bit about what's included in that rule. And again, the EEOC, and this is one of the reasons why it took so long to get this rule published, they got more than 100,000 public comments once they put out their notice of proposed rulemaking. And to be clear, one of the things that they did clarify when they put out the rule was that the PWFA only applies to employees or applicants themselves. It does not apply to individuals who are associated with an employee. So for example, an employee's spouse or child, those individuals are not going to be covered by the PWFA. It only applies to employees or, if the circumstances are correct, an applicant. Okay, so the final rule was designed to provide clarity to employers and workers about who is covered, the types of limitations and medical conditions that are covered, how individuals can request reasonable accommodations, which is definitely a thorny issue and lots of landmines there, and provided numerous concrete examples. So as we get into the nuts and bolts of the PWFA, we're going to walk through all of these different terms, give you some practical guidance, and hopefully make it so that you don't actually have to read that 408-page rule. You're going to learn everything that you need to know by listening to this webinar. So I'll turn it over to Brittany, who's going to walk through who's a qualified individual.
Thank you, Nancy. So first, to gain protection under the PWFA, an employee or applicant has to first be qualified. So then the question is, well, who is qualified? So the PWFA provides 2 ways for employees to establish that they're qualified. The first is similar to the ADA, where an employee or applicant with or without a reasonable accommodation can perform the essential functions of the employment position. That individual would be qualified. The second way would be if an employee or applicant cannot perform all essential job functions, even with reasonable accommodation, the employee could still be qualified for accommodations under the PWFA if the following is met. So the first thing would be that the inability to perform an essential function is for a temporary period of time. All the italicized words are words that we're going to get into because they're further defined in the rules. So don't worry, we will add some color to those in a minute. The second is if the essential job functions could be performed in the near future, and the inability to perform the essential functions can be reasonably accommodated. So what does temporary mean? The PWFA itself does not define temporary or in the near future. The final rule defines temporary as lasting for a limited time, not permanent, and may extend beyond in the near future. So you're probably wondering, does near the future mean when robots inevitably take over the world? Not really sure, but the final rule does define in the near future as generally 40 weeks from the start of the temporary suspension of an essential function. The final rule does differ from the proposed rule in that the 40-week period applies when the condition for which an accommodation is being sought only when it relates to a current pregnancy. So that 40-week mark of a a typical pregnancy is only used whenever the accommodation is related to a current pregnancy, not before pregnancy or a pregnancy-related condition that would come after the pregnancy is terminated. So the EEOC has stated that it's necessary to tie the definition of in the near future to the typical length of a full-term pregnancy, which is 40 weeks as we just discussed. However, the final rule does not define in the near future for childbirth or related medical conditions. So if you're getting into accommodation requests for childbirth or related medical conditions, that's really going to go to a case-by-case determination to really determine what in the near future will require. So under the ADA, the inability to perform essential job functions with or without a reasonable accommodation is disqualifying. But that's not the case under the PWFA, so long as a suspension is temporary and the individual is expected to be able to perform the essential function in the near future, and the employer can reasonably accommodate the inability to perform the essential functions. If there is no reasonable accommodation for the temporary suspension, the individual is therefore not qualified. Additionally, the employer does not need to provide a reasonable accommodation that includes the suspension of essential functions if it will cause an undue hardship. And Nancy will talk about how you meet the definition of undue hardship in a little bit. The final rule states that the time an employee is on postpartum leave is not factored into the equation for how long an employer must consider waiving an essential job function. Additionally, whether the employer can reasonably accommodate a person's inability to perform the essential function must be reassessed upon a return to work, regardless of whether the employer provided the same or a different accommodation during the pregnancy. So really, whenever someone's coming back to work, you need to look at the accommodation, and if you can reasonably accommodate that request at that time, and if that's going to be in the near future or temporary at that time, you wouldn't account for the 6 weeks or however long that individual was on postpartum leave into the definition of temporary or in the near future.
And so one of the things just to keep in mind, and that you're going to be hearing about a lot during the course of this webinar, is we're going to be referring to a lot of different laws other than just the PWFA. So as those of you who practice in this area know, so many times there's overlap between, let's say, the ADA and FEMLA. That's going to continue in this circumstance. So for example, someone who's potentially been accommodated by providing them with leave under the PWFA, they have the baby, that's not going to change what they're entitled to with respect to if they have a FEMLA, if they're entitled to FEMLA leave. They may be entitled to some sort of leave under a state law that may be applicable in their jurisdiction. There may be paid family leave, unpaid leave, sick leave in your jurisdiction. So all of these laws are going to work together, and sometimes maybe be a little bit difficult to manage, but just be aware that just because you've checked all the boxes with respect to PWFA, that doesn't mean that there are not other laws that may be applicable to the person's either request for leave or for an accommodation. So back to the PWFA, what's covered? What is a known limitation? Okay, so let's talk about that. Employers are only obligated to accommodate an individual's known limitation. Okay, this is one of the areas where you really need to be doing some type of training or education with your frontline supervisors. The PWFA is very clear that when a supervisor or someone who's responsible for the employee's work, or the recruiter, if you're talking about an applicant, once these individuals are aware of a known limitation, the person says, you know, I'm expecting, or I need to do such and such, I need to take a rest every 10 minutes, every hour because I'm 6 months pregnant, or whatever it is, even if that individual is not saying PWFA, they're not saying I'm requesting an accommodation, they are just referring to something that they need, and it is related to a pregnancy, childbirth, or other related medical condition, that is putting you as the employer on notice that you have an obligation. You are going to need to enter into the interactive process to determine what the accommodation is that's being requested, whether it's something that you can provide. So this isn't something where you can put in your handbook, hey, if you have a need for an accommodation under the PWFA, you know, contact HR. And if the person doesn't do that, you can say, well, hey, they never contacted HR. We didn't know. That is not good enough. It's also not good enough to say, well, we have a form that somebody is supposed to fill out and check all these boxes and provide this information to request an accommodation, and the person didn't do that. That is not going to be sufficient to meet your requirements and obligations under the PWFA. So really, your frontline supervisors are the people who need to be trained. They don't need to do the interactive process. In fact, that's probably not a good idea. They need to be the ones who say, oh, you know what, you need to call fill in the blank at HR. That person handles, you know, these types of requests or accommodations, or the supervisor needs to send an email or pick up the phone and say, hey, I just heard from one of my employees, you know, that she's pregnant, she's requesting this, you know, can you get somebody to contact her, et cetera. So it's really, really important to make sure that you as an organization, and whoever's going to be responsible for PWFA compliance, that they actually know what employees have needs and are requesting an accommodation. Again, what's a known limitation? So we've talked about the known piece of it. A limitation is any physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Now, an important thing to remember is that there is no severity threshold, number one. Number two, a limitation can be something that the individual already had a specific condition, and maybe it's being exacerbated by a pregnancy or childbirth. That is also going to be a limitation. Certain limitations are things that you would obviously expect or anticipate for a pregnant employee, but some of these may be ones that, again, an employee had before they ever became pregnant, and now the issue has been exacerbated because of the pregnancy. Again, a limitation becomes known to the employer when the employee or an employee's representative, and we're going to talk about what that means, has communicated it to the employer. So the employee's representative, that sounds like some sort of like really official title or something, but it includes family and friends. So let's say the employee's spouse calls HR to say, you know, my spouse is in the emergency room, or she's not gonna be able to come in today because of morning sickness or whatever. That's going to put you on notice as well. A healthcare provider, a union representative, other representatives, which again could be somebody, let's say at a staffing agency, you're looking at an applicant, and the staffing agency or recruiter shares something with you, that's also going to be an employee representative. Okay, so again, what is covered? The communication, again, does not need to be in any specific format. If you have a form, that's great, but you cannot require the person to have used the form in order to have put you on notice. It doesn't have to be in writing, it can be oral, and again, it can be communicated pretty much to anybody with some sort of supervisory authority or obligation to deal with compliance in this area. And again, if you have something in your employee handbook, which we definitely encourage you to take a look at your handbook and see what's in there as far as a communication policy and request for accommodation to make sure that you're addressing this. But even if you have a preferred method for requesting an accommodation, they do not have to follow that in order to put you on notice. They don't have to use magic words, in other words, in order to let you know that you need to engage in the interactive process and determine whether or not a reasonable accommodation is available. Okay, so what happens once you become aware of a limitation? It's known, and again, maybe this is filling out the form, maybe this is telling their supervisor, maybe it's calling HR. You need to engage in the interactive process. And what I would say is sometimes the interactive process can be very, very simple. I mean, it can simply be phone call to HR, you know, I'm expecting, I need this or that, or my doctor's advised me to do this or that. HR says no problem, and that's pretty much the end of it. It doesn't have to be a super complicated process. Other times it's maybe creating issues from an operational or staffing standpoint. It may become more difficult as the employer assesses whether or not this is something that can be accommodated, or maybe there's an alternative accommodation. But you should always, even if you think that this person's request is crazy and from outer space, you still need to engage in that interactive process every single time. So that should be step number one. And again, how might workers alert you to the fact that they are in need of something that would be an accommodation under the PWFA? Here are just some examples. This is not obviously an all-inclusive list. I'm having trouble getting to work at my scheduled time because of morning sickness. Okay, again, this is a comment that may be made before somebody is visibly pregnant. You may not even be aware that the worker is pregnant, but they share this with you or with their boss, or the call-in line. If you have something where people are supposed to call in, if they're running late and they leave a message or something, or they text, indicating why it is that they're going to be late for work. If they've shared this information with you, you are now on notice. There is a known limitation. Same thing here. I need more bathroom breaks because of my pregnancy. I need time off from work to attend a medical appointment because of my pregnancy. And all of these are referring to pregnancies, but the same thing would apply if, you know, I'm getting fertility treatments. I need some time off for a medical appointment with my fertility expert. Those, anything like that is going to put you on notice of a known limitation. Okay, so number one, employers should respond promptly to accommodation requests. Okay, this is nothing new. This is the same thing I would tell you if we were talking about the ADA. You need to be prompt and be communicative with the employees. So for example, sometimes employees may request an accommodation that you really need to jump through a number of different hoops. A number of people have to sign off on it. And so there may be some delay. it's really important to be communicating with the employee and letting them know, hey, I'm making progress on this. I've talked to 2 out of the 3 people I need to talk to, or so-and-so's on vacation. They'll be back on Monday. I'm going to address it with them at that time, just so that the employee knows you are acting on the request for the accommodation. Delays can be a violation of the PWFA. And again, you know, if somebody requested something at 5 o'clock on Friday and you don't have it in place at 8 a.m. on Monday, that's probably not going to be seen as a delay. But again, we need to be responding promptly and addressing the accommodation requests and gathering whatever additional information we may need in order to go through that process. Now, as a best practice, the final rule suggests granting the accommodation on an interim basis, and this isn't always possible, even if the employer believes it needs more information. So this is something you can choose to do. It's not required, but you can say, okay, listen, for the next week while we figure out how we would address this particular request you've made, we're going to go ahead and, let's say, for example, allow you to work from home if that's what the request was for whatever reason. So that's something you can choose to do. You do not have to do that. If you do provide that interim accommodation while you're going through the interactive process, that's certainly evidence that you did not engage in some sort of unnecessary delay. So that's just sort of a get out of jail free card if you go ahead and do that. Sometimes that's not possible because of the operational issues that might be caused by the request, but it's something to keep in mind if it is something you can do. Okay. Let's talk a little bit about this particular part of the PWFA, which has gotten a lot of attention, a lot of press, and we'll be talking about some of the litigation that's arisen as a result of this. What is covered? So pregnancy, most people are like, got it, understand that. Childbirth, got it, understand that. Or related medical conditions. And again, there's a whole list here of things that fall within the definition of related medical conditions. Pregnancy, past pregnancy, potential pregnancy. So again, this is, you know, fertility issues, lactation, use of contraception, menstruation, infertility and fertility treatments, endometriosis, miscarriage, stillbirth, or having or choosing not to have an abortion, among other conditions. And as you can imagine, in our political environment, having the use of the word abortion included within this definition of what is covered under the PWFA is certainly something that has been a lightning rod of sorts. So when the EEOC clarified what was meant by these related medical conditions, it was talking about new and physical and mental conditions originating during pregnancy, or again, those that were pre-existing conditions that are exacerbated by pregnancy or childbirth. So it may be something that's not necessarily associated with pregnancy or childbirth, but it has been exacerbated by the fact that the employee is pregnant. So again, the inclusion of abortion is obviously one of the most controversial aspects of this rule. And the EEOC made it very clear in the rule that it decided to include abortion by stating nothing in the PWFA requires an employer to pay for an abortion, but employers are required to accommodate the necessary time off for the procedure and recovery under the PWFA. So there have been a couple of prominent sort of legal actions related to the PWFA. One you may have seen is that 17 states, their attorneys general, are suing the EEOC over the rule. And the complaint that they filed addresses the costs that are going to be imposed on state governments that they say are improper. And the real focus of the litigation is an argument that the PWFA infringes on state sovereignty because these are states that have rules prohibiting or limiting abortion with rare exceptions. So this is 17 of those states. No injunction has been issued yet. It was filed in the federal court in Arkansas. We're waiting to see how that proceeds. If there is an injunction, what are the limitations of that injunction, and what states or jurisdictions are covered? Is it a nationwide injunction? Those are all things yet to be determined. I'm sure whatever the result is of the case in district court in Arkansas, I'm quite confident that that will be appealed. For now, as far as you're taking action, getting your policies in place, training, etc., this isn't really something that's going to put a hold on that. You should proceed forward with getting yourself ready to be in compliance with the rule. Another piece of litigation that you may have heard about is a case that was filed in Texas, again in federal district court, saying that the PWFA was unconstitutional. This was a case that was filed by the state of Texas, and the district court in that case did grant an injunction with respect to the enforcement of the PWFA with respect to the state of Texas and state agencies in Texas. This has no impact on private employers, whether you're in Texas or not in Texas, doesn't make any difference. That injunction has no impact whatsoever on you. It's being appealed to the Fifth Circuit. We'll see what happens. And really the basis of this particular lawsuit, we won't get into all of the stuff that's like for legal geeks. But anyway, if you're a real nerd, you can look into this. But it's based on the fact that the PWFA was passed using quorum rules and proxy voting. You may remember in Congress during COVID, they implemented some rules where people did not have to be physically present in order to vote on legislation. And because the PWFA was passed at a time when there weren't the number of individuals present for purposes of we'll call it the traditional quorum rules, the state of Texas argued that the PWFA is unconstitutional. Obviously, if this is upheld, it'll have significant impacts with respect to other pieces of legislation that were passed with similar procedures, because a fair amount of legislation was passed using that proxy voting. So this could have some implications far outside the PWFA. Okay, but back to the PWFA, I'll turn it over to Brittany, who's going to talk a little bit about the severity requirements.
Thanks, Nancy. So a reminder here, the final rule confirms that under the PWFA, there is no severity requirement. The request for an accommodation can be because of a modest, minor, or episodic condition, and there's absolutely no threshold involved. Now, another area you're going to want to train HR professionals on is the documentation requirements and lack thereof for the PWFA accommodations. The EEOC, as Nancy touched on, the interactive process really encourages employers and employees to keep an open dialogue about the accommodation needs. The final rule also clarifies that an employer is not required to seek supporting documentation, and they should only really do so if it's reasonable under the circumstances, if the employee has a qualifying condition and needs an adjustment or change due to the limitation. So there's a couple, this is kind of a minefield part of this regulation that's come down is, when can you ask for documentation? What's too much? When can't you ask for documentation? And the final rule does include some absolute no-nos, so we'll kind of go through those now. So the final rule limits employers to seeking documentation that, number one, is the minimum sufficient to confirm the physical or mental condition underlying the employee's limitation. So they can say, I have a back injury, my ankles are swollen, I have a lifting restriction, and I have a need for rest. And this documentation would confirm that the limitation is related to, affected by, or arises out of pregnancy. So my ankles are swollen because I'm pregnant would be an example. And it would describe the adjustment or change needed due to the limitation. For example, no lifting more than 20 pounds for 3 months, safety gear, work functions that should be suspended. And in the example that we're kind of going on, if you say, my ankles are swollen because of my pregnancy and I need to sit down 15 minutes every hour. That would be how the final rule limits employers to seeking documentation just specific to those 3 buckets of information. The EEOC also noted that the employer can ask an employee for the expected duration of the requested modification. So for that example, employee comes in and says they need to sit for 15 minutes out of every hour. You are able to seek to ask that employee about how long is the expected duration from the doctor that accommodation is going to be needed. So these are five instances where the final rule expressly prohibits employers from seeking supporting documentation. So number one is when the limitation and need for a reasonable accommodation is obvious. So if someone's 8 months pregnant, they say they have to go to the bathroom a few extra times, and you're going to give them a hard time and request for documentation. That's something that EEOC has said, we're not going to do that. That's strictly prohibited. Also, when the employer already has sufficient information to support a known limitation related to pregnancy. So if you already have any documentation or information related to the accommodation that employee is requesting, you will not be permitted to seek additional documentation. Also, when the request is one for 4 predictable assessment accommodations, we will get into the further definition of that term later. But if it does meet any of those 4 examples, you would not be able to seek documentation for those. Number 4, when the request is for a lactation accommodation. And 5, when employees without known limitations under the PWFA are receiving the requested modification without having to support documentation, and that's per the employer's policy or practice.
Yeah, and I think the takeaway from this, Brittany, is that, requests for documentation, again, this is something that can become kind of automatic within the HR department. Okay, somebody's requesting leave, somebody's requesting an accommodation. Let's churn out the paperwork, send them an email with the certification, medical certification requirement for doctor's note, et cetera. It's just sort of this almost Pavlovian response to a request for accommodation. That's something that really needs to change here, because I would say, if you're up in the air as to whether or not should we require this person to get some sort of information from their medical provider, I would say if it's not clear to you that you should or can be doing that, you should err on the side of caution and not request it.
All right, another reminder here, just like with documentation under the ADA, any documentation that's submitted to you related to a PWFA accommodation request should be kept confidentially, just as you would with ADA documentation, and completely separately from an employee's personnel file. So the EEOC does provide examples of reasonable accommodations that it finds would address known limitations related to pregnancy, childbirth, or related medical conditions. And going back to that example of predictable assessments, so meeting any of these 4 requests for accommodations, the EEOC has said in virtually all cases, they're going to find that it is not an undue burden for an employer to meet these. And therefore, if these are one of the requests you receive, your ability to seek further documentation is extremely limited. And those are carrying or keeping water near and drinking an employee's workstation, additional restroom breaks, sitting for those whose work requires standing, and standing for those whose work requires sitting, and breaks to eat and drink as needed. So here are some additional examples of reasonable accommodations that the EEOC has provided. Something like changing uniforms or dress codes, and providing safety equipment that fits an individual who's pregnant, changing work schedules to shorter hours, part-time, a later start time, telework, temporary reassignment, leave for healthcare appointments, reserved parking that's closer to the building, temporarily suspending one or more essential functions, light duty, and some leave to recover from childbirth or other medical conditions related to pregnancy or childbirth. And Nancy touched on this earlier, but the final rule does also include lactation accommodations, and an important difference between the PUMP Act and the PWFA is that it also includes nursing. So if an employee is working from home and their baby is at home, an accommodation would be allowing time for them to nurse, not just pump. And also if there's like an on-site daycare or any type of proximity between the baby and the mother, time to nurse rather than just pump is required under the PWFA.
Okay, so I'm going to talk a little bit about undue hardship. The EEOC has adopted the same standard for undue hardship in the final regulations as they had put in the proposed regulations. So when an employee can perform all of their essential functions, the EEO stated that undue hardship has the same meaning as under the ADA and generally looks for significant difficulty or expense for the employer's operation. So one of the things to keep in mind here is that, again, this is going to be an individualized analysis. So for example, a small business that has 25 employees is going to have a different standard for what's an undue hardship for that organization as opposed to, for example, Target or Walmart. It's going to be a different analysis. It's also going to be different based on the individual's function within the organization. So if an employee cannot perform all the essential functions, and the accommodation is the temporary suspension of an essential job function, the employer needs to consider the ADA definition of undue hardship and the following relevant factors. So these are all things that you can look at to determine whether or not you can meet the undue hardship standard. And again, as you become a larger organization with more revenue, more employees performing the exact same job as the individual who's seeking an accommodation, it becomes harder and harder and harder to be able to demonstrate that you have an undue hardship in terms of providing this accommodation. So the first thing to look at is how long is this person or applicant going to be unable to perform the essential functions? And again, is it somebody who is 8, 9 months pregnant? They're going to be going out on their parental leave, in a matter of weeks. And in those last weeks prior to them going out on leave, they need some sort of accommodation. Most of the time, a short period of time is something that's going to be fatal to a claim that this is an undue hardship that you cannot accommodate. Second factor, is there work for the employee to accomplish by allowing the employee to perform all of the other functions of the job, transferring that person to a different position or otherwise? So again, if this request for an accommodation is something that where the employee, 98% of what's in their job description or what they do on a daily basis, they're still going to be able to do that. And it's just this one function that's 2% of the time or once a month or once a week that they have to do, and they're asking not to do it or to be relieved of that. That is not, it's going to be very difficult to demonstrate that that is an undue hardship. Is there a vacant position that's open that would alleviate whatever the issue is? Well, you have an open position. What is the undue hardship of putting that person there temporarily to allow them to continue to work and perform? So that's something to consider. The nature of the essential function, including its frequency. This goes back to, again, is this half of what the person does every day? Is it that type of essential function? Is it just something you list on the job description so that, in the event you need to assign somebody to do it, you feel comfortable because it was listed in the job description? I mean, that's, again, something you have to look at on an individualized basis. Okay, the next factor, whether the covered entity has temporarily suspended the performance of essential job functions for other employees in similar positions. I mean, this goes back to what we always talk about every time we do one of these webinars, or I get on the phone with one of you with a question. Let's talk about consistency. What have we done in the past for somebody who maybe, isn't covered by the PWFA, but has a different set of circumstances? Did we already do a similar accommodation? How can we say we could do it for employee A, who maybe is our superstar, most favored, most talented employee, but we're not going to do it for employee B, who is actually covered by this law? So consistency is really important. Whether there are other employees, temporary employees, third parties who can perform or temporarily be hired to perform the essential functions. So, this is one of those things where sometimes an employee is in a position, and it is a critical position. You need somebody in the role who can perform that function, or you need that position to be filled. Can you fill it with a temporary employee? That is a question that we always ask you, because if there's an easy fix, hey, this is the receptionist position. We cannot not have somebody sitting at the receptionist desk to meet our guests and let people into the building or whatever it might be. You can hire a temporary worker from a staffing agency to be your receptionist for 2-3 months, et cetera. So you have to look at that. If it's somebody who's in a individual role, that's a high level, non-duplicative role, like it's your CFO, then maybe there's a different, maybe this isn't something that can be filled on a temporary basis, but it's something that you need to consider. And finally, you have to look at whether the essential functions can be postponed or remain unperformed for any length of time and how long. And again, this is really going to depend on the role that this person is performing. Are they part of the operation such that you're not going to be able to churn out the product that your clients are expecting on time because this person is not performing this function or this role? Well, that's certainly going to be a problem. If it's something that's like, well, as between two things we could really focus on, the list of things we need to do on list A and delay the things that are on list B, well, then that's something that's going to be an indication that this is not an undue hardship. So let's talk about 5 prohibited practices that were specifically identified by the EEOC as absolute no-nos and violations of the PWFA. Number 1, failure to provide reasonable accommodations. So again, remember that those predictable assessments that Brittany talked about, those things are going to be just like no-brainers. Those should just be absolutely automatic, barring some sort of really unusual circumstances for your workplace. Again, reasonable accommodations, getting into that interactive process with your employees and make sure that you're having a conversation about whatever it is that they may be requesting as an accommodation. Number 2, requiring employees or applicants to accept an accommodation. Now, again, this is part of that interactive process. You need to have a discussion, have a dialogue about the types of accommodations that the employee is requesting. And if there are multiple accommodations, the employer is permitted to identify an effective accommodation, even if it isn't the one that the employee or applicant wish to have. So that's similar to the ADA. You do not have to do the accommodation that the employee requested if another effective accommodation is available. Number 3, no-brainer, denying equal employment opportunities. So again, this just goes back to what was already in place. I mean, you cannot be discriminating, retaliating against individuals who are either requesting an accommodation or are pregnant, etc. Number 4, this is an important one. You cannot require the employee to take leave when other accommodations are available. So sometimes it seems like the easy answer is just like, oh my gosh, throwing my hands up in the air. This person, needs this accommodation, needs this amount of time off, needs to rest 15 minutes every hour, blah, blah, whatever it is. Instead of actually thinking through the accommodation that's requested, you know what, she's 8 months pregnant, she's going out on parental leave in a month anyway, let's just have her take leave and just kind of be done with this, and we're not gonna monkey around with this interactive process. That is absolutely prohibited under the PWFA. You cannot require somebody to take leave if another accommodation is available. So again, and the person could very well be asking for leave as the accommodation. That's certainly something that you can walk through that interactive process with. But just sort of saying, gosh, this interactive process is too much of a pain, it's a headache, it's going to make other people mad. So let's just tell the person to go out on leave early. That is not a solution. And finally, obviously taking adverse action, i.e. retaliating against a worker for seeking or using a reasonable accommodation. Now, most people understand very simply, like, saying like, let's fire that person, let's demote that person. They understand that's taking an adverse action, but let's also be aware of things that sort of could be some sort of disciplinary action against a worker. Some employers have something where they're measuring a worker's productivity, they're measuring keystrokes, they're measuring, how many calls is this person processing per hour if they're a customer service rep or what have you. And let's say as an accommodation, that employee has been given, the opportunity to take a rest for 10 minutes every hour or what have you. And let's say that impacts their keystrokes per hour or the number of calls they're taking per hour. You cannot discipline that person or give them a poor performance evaluation because they're not hitting the metrics or numbers you set out, when the reason they're not doing that is because of this reasonable accommodation that's been provided by the employer. So that's just something to keep in mind, that this doesn't just refer to, I'm going to fire this person, I'm not going to hire this person because of a reasonable accommodation. It can go into exactly how we evaluate their work and productivity. Okay, so very quickly, if you don't listen to me and you do any of those 5 prohibited practices, then this is where we end up: remedies and enforcement. So remedies under the PWFA, they mirror what's in Title VII of the Civil Rights Act and include injunctive and equitable relief, compensatory and punitive damages, and attorney's fees. So be aware of that. It's certainly not something that you want to get in the middle of if you can avoid it. But employers do have an affirmative defense to money damages if they can demonstrate that they took good faith efforts to work with the employee to identify and make reasonable accommodations. And so this is really important. Again, even if you don't do the process perfectly, even if at some point down the road in an EEOC charge or in a piece of litigation, somebody says, hey, you didn't reasonably accommodate me, and a court says, or another fact finder, yeah, you know what, that's you should have provided this reasonable accommodation. If you can demonstrate your good faith effort, you've gone through the interactive process, and maybe you just kind of came out on the wrong side, made the wrong decision, but you exercised good faith, you're going to be able to have an affirmative defense to money damages. So that's something that's very important. Okay, a quick review of some best practices for employers. So this is kind of your checklist, your to-do list, your takeaway from this presentation. First of all, very important to become familiar with the final rule and the interpretive guidance. Hopefully this webinar has given you some information that will make that easier, or maybe you've identified some areas where you have concerns or need to take a look at your policies and update them. Take a look at the examples of reasonable accommodations and identify those you could potentially make for a qualified employee. So just be, aware of sort of all the options that are out there so that you are prepared if somebody comes forward and again asks for additional rest breaks, asks to work remotely, asks to change their schedule. How would you address those sorts of things? Review your pregnancy accommodation policies and any related forms. And again, we're not using documentation for every single request that people make, but to the extent that a form is necessary, make sure that they comply with the final rule. Training HR and management. I cannot tell you how important this is to make sure that, the spidey sense goes up, that whoever it is who might be on the front lines of getting this kind of request knows how to handle it and who to call to say, hey, heads up, FYI, this person who works in my group has just alerted me, she's pregnant, she's made this request, or even just that she's pregnant, to get it on HR's, to have it be something that they're aware of so that they know, okay, we need to be aware that we may have some accommodation requests coming here. And finally, engage in that interactive process with employees who request an accommodation based on any of the covered conditions. Again, interactive process, document everything you do, even if it's something super simple, if it's something complicated, if there was a delay in making a decision about whatever accommodation somebody requested, how you communicated, what you did to be efficient in terms of providing a response as soon as possible. So those are our things that we wanted to cover today. I think we do have a couple of questions that people have raised. I don't know if we can get to all of them. So let's see here. Let me look here. Sorry for a second. Okay. One of the questions is, let's see. Oh, I can't see. I think it's, oh, sorry. Okay, here, I'll let them, they're fixing the screen for a second. Let me answer another question that I can see. Someone asked a question, is bonding time covered under the PWFA? No. Okay, so that's something that can be covered under the Family Medical Leave Act, but bonding time specifically, even for the pregnant employee, which again, the Pregnant Workers Fairness Act only applies to the pregnant employee, not to the other parent. Bonding time is not covered under the PWFA. That's a good question. We did cover this. You have to give the accommodation that the employee requests. So the employee comes forward and says, you know, I'm asking to please work from home because of my morning sickness, let's say. And you go through the interactive process. You figure out that the morning sickness, you know, it tends to happen every morning from 7 to 9 in the morning. The person's supposed to report to work at 8 a.m. You could say, well, instead of coming in at 8, why don't you start coming in at 10 a.m.? That could be a reasonable accommodation that isn't work from home 5 days a week. Again, it's got to be an effective accommodation, but it does not have to be the accommodation that the employee requested. Let's see here. Okay, the question about giving an employee leave or using leave as an accommodation. Can leave be an accommodation? So I think the question is really getting to that thing that's prohibited, which is you cannot force people to take leave as an accommodation if there's another effective accommodation available. If leave is what is requested by the employee, that's certainly permissible. If leave is the only effective accommodation that's available based on the person's condition and their restrictions, then that is also fine. The thing that is prohibited is essentially forcing someone to take leave when another accommodation could be available. Okay, a question about, okay, the exacerbating existing conditions. If somebody has an existing condition that's also a disability, is that covered by the PWFA or the ADA? It's actually both while the person is pregnant. Because again, if a condition that, let's say it was, or even if it wasn't a disability under the ADA, but it's been exacerbated because of the pregnancy, while the person is pregnant, that's going to be covered by the PWFA. If the condition continues post-pregnancy and otherwise qualifies as a disability under the ADA, then you're basically back under the ADA rubric and you would go through your normal sort of accommodation and interactive process with respect to that condition, which, you know, again, it's got to qualify as a disability under the ADA post-pregnancy. Again, do you have to have a form for employees to request accommodations? Does the employee have to use it if you provide them with a form? You do not, as we talked about, you know, documentation with respect to these requests can can really be a problem. Again, err on the side of not necessarily requiring a certification or doctor's note if you're unsure about that. But again, if the person informs HR, informs a supervisor, informs somebody who's responsible for their tasks that they have a need for an accommodation, and they do it orally, they don't do it on your form, they didn't follow your policy and call the right person to say it, it doesn't matter. You are on notice of that need, and you need to go through the interactive process and determine whether or not a reasonable accommodation is available without undue hardship. It is actually 1 o'clock. I want to be respectful of everybody's time. I know there were a couple of questions that we did not get to. We will try to follow up with those if we can after the presentation. Again, thank you so much for attending. I hope you found the information helpful. If you have questions that we were not able to address today, whether you put them in the chat box or you didn't, please email or call your regular Thompson Hine employee or lawyer. If you're not a current Thompson Hine client, feel free to contact me and we can discuss available options to address your needs. Again, I hope you found the webinar helpful. Brittany, thank you so much for joining me in this presentation. And thanks for joining us and enjoy the rest of your day. Take care. Bye-bye.